Now you can unmute yourself.
I can.
I keep that much control in my hands. Something you need to control.
I saw, yeah, Vikram's in charge, I tell you. So I have a barking dog this morning. So I just wanted to warn you of that. That's why I was trying to mute so that I could spare you additional input from the canine community, but
we're okay with that.
apparently
Okay
I won't be able to do that.
Yeah.
So we're all family now, with the barking dogs. So that's all good.
But where is the dog? Where is the dog?
Oh, she's running around the house.
Okay.
So yeah. So we'll hear from her in the future, I'm sure. Anyway, yes, I'm very excited about this, Vikram. I think that it's so interesting and so wonderful, the community that you've created online, the international community, and I think a testament to your success in that is the number of people who wanted to participate in this and have dialogue and share their culture, but also I think, really cross-pollinate on mediation ideas and creating connections. So I think that really is one of the most, valuable and wonderful uses of social media. And you've really taken that and run with it. And so I just wanted to say I appreciate you, and I'm sure everyone participating in this appreciates you.
Which is what I like about you, at least on LinkedIn. Also, you put this out. At least I really like that, because I have always been saying it's nice to be appreciated. So when you put out those posts and you put my name there, it always feels good.
Yes, exactly. No, you got to walk the talk, right? So, and support people and do that. So I'm going to post about some of the sessions that you've had and Ken's keynote and things like that to direct people to them as well. So I think they're quite valuable. I do think that you have an interesting relationship with Ken going, where it's really an evolution and ongoing discussion with him at various points. If you follow your different interviews and seminars and keynotes with him, it's really an education in itself to listen to Ken on all of those things. So that's really wonderful. So
and let me put it out there. He's a wonderful person. I really like him. I mean, he's like like I say, a beautiful soul. That's what I always put across.
Yes, it comes across. It comes across in all of it, and also a very innovative thinker. So I think he causes you to think differently about things and get a different perspective. And I always get something from his sessions. I hadn't listened to his keynote, but I listened to it yesterday. And actually, that'll be a jumping off point for what I'm going to talk about today. And I have, a little different, I guess, a little different background than a lot of folks who might be participating. I am a lawyer in the U.S. and I focus on appellate law. So I'm involved in, creating the law, making the law, setting legal standards, and, but still in an adversarial setting, arguing in court to a panel of judges in our Supreme Courts and our courts of appeal. So I have a little different view with regard to the role, sort of the public role of law, and the importance of having the rule of law develop, especially in a country where a lot of it is common law still. And so you need to have that public component of disputes so that you can get some guidance about where the law is and what the law expects of people, what the policy is. So there's still that role that mediation itself really can't fulfill. But I also have an additional experience serving as a temporary judge and working in some of our more creative courts in the United States as well. So from those backgrounds, I thought I would talk a little bit about sort of mediation and legal culture, about justice, problem solving, and the rule of law, and really how these two can interact, and how the legal system maybe has an opportunity to incorporate some of the mediation culture into it, and what that creates. Is there something legal plus when you put a mediation culture aspect into the rule of law? So,
MC, I won't interrupt you after this. Is last time I'm
yeah,
interrupting you.
no problem.
You must tell people about the philanthropic work you're doing, but because everyone thinks of lawyers in a certain way, but this is not that kind of lawyer. She does a lot of good things. Please talk about that also, and of course the book, a book also, a little bit.
Yeah,
I'm not going
sure.
to. I'm not going to say anything beyond that.
No, that's okay, Vikram. Thank you. Yes, I started my practice as an appellate lawyer doing on a pro bono case in the United States Supreme Court. And ever since, so for the past 25 years, I have done a lot of pro bono work and impact work, both in the United States at the US Supreme Court and the California Supreme Court and the Ninth Circuit, which is our federal court, and also in the international realm. And I'm going to talk a little bit about that today as well, which is the international human rights courts. I've also worked in those pro bono. And I'll talk about one of those cases today against Mexico. And so to me, service is part of being a lawyer. And so a rough estimate would be about 6,000 hours of time donated over the past 25 years to various cases. I do 1 to 2 cases a year pro bono, and some of them have changed the law. So largely in the realm of women and girls, but also a range of other areas. So when I talk about the rule of law and the public role of the justice system, I mean it in a significant way in cases like this. If we weren't able to bring these cases, there wouldn't be changes. And I think sometimes changes in the culture come from legal changes as well. There's an interplay. So that's the backdrop. Some of the cases are student sexual harassment in schools. A lot of the cases are taught in our constitutional law books, and they're taught in law schools that I worked on. So that's part of my background. And then, as Vikram mentioned, I also have a publishing company, and I write books in connection with that are not legal books, and focused really on advice from my mom and advice from other mothers to give to their children in a journal, their own journal that they can put together for their children, and then some compilation of my mom's notes to me as well. And I'm publishing other kinds of books as well. So that's my little side gig, is also writing and publishing non-legal books. And many of those books also have benefited various charities related to children. So it's also a service entity in that regard as well. So that's kind of my orientation. And so I wanted to, I know everyone's on mute, but I don't know if people can still put things in the chat. Vikram, can they still type in the chat? Okay. So the first thing I wanted to, because you just did your summation and you're thinking about where we've come and what we've talked about so far in the symposium, I was wondering if you could put in the chat in sort of 1 or 2 words, what does a mediation culture mean to you? What is like the first word or 2 that comes to you when you say we have a mediation culture? I'm going to look to see.
You're the only one who won't be able to see. I'll be the only one who'll be able to see.
Oh, okay.
Okay, I know. I'll open it to everyone. I don't do that only because I get distracted with a lot of other things.
Get distracted. Okay. All right.
Actually, but I've opened it out. You'll see it now.
Okay.
Please,
all
please
right.
put,
Perfect.
everyone,
Thank
please
you,
put down
Vikram.
whatever MC is saying.
Yeah. So 1 or 2 words, when somebody says we have a mediation culture, what comes to mind? I'll tell you a couple of things that came to my mind. Maybe I'll get folks getting their coffee and, putting in some thoughts. But a couple of things that came to my mind were, collaborative, creative, extra legal, and consensual. It's usually it's what the parties want and what the parties have reached, what's best for them, individually. those are some of the things that came to mind. And I know that Ken had talked about this as well. Obviously, the culture in which you're mediating has a factor as well, and that each of the people who come to mediation have their own culture, and it's a cross-cultural communication even within a mediation. So I wanted to focus on and kind of jump off of one part of Ken's keynote, where he focused on culture, context, and mediation. And he observed at one point, I thought this was really a different way of thinking of it, but I think it's really a holistic way of thinking about conflict and resolving conflict. And that there are really three places where conflict arises, and you need to address all of these places in order to really fully resolve the conflict. One is internally with each person. The other is relationally. I'm thinking that's more on an individual or small group level. And then the third is environmentally. So that includes contextually or culturally. And all of those different things come together, can create conflict or can help heal conflict. And unless you've done it at all levels, there's still going to be something there that's unresolved. And because mediation is a party-centered process, it seems like it's really can be tailored and catered to the particular needs of the parties, their interests, their rights, in a way that it's hard to do in the legal system, because the legal system is concerned largely with the environmental, the contextual, and the cultural aspects in the legal system itself. So, so when conflicts reach the legal system, the context then transcends the individual parties. The law and broader justice become concerns. It's now much more than a dispute between two parties. And indeed, as I mentioned, in the common law jurisdictions, that's true, because unless we have a case that proceeds to appeal or results in a legal decision interpreting the law and applying it to these facts, we don't develop our law. We don't have guidance about how we should act within the legal system. So on the one hand, the mediation itself allows for a lot more, maybe much more satisfaction on the individual and relational level for people, but it fails to provide this other context of the rule of law. And so if all conflicts went through mediation, then you would have a dearth of law created. So it's important to think about that in terms of, is it one size fits all mediation for all disputes? And is it always a higher good for the culture, for the society? You have to retain a balance between this, between the public role that law plays beyond the direct parties to the case and the best resolution of conflicts. And also what will provide the most holistic resolution to something in a way that will prevent future conflicts, right? If you get to the core and the root of the problem, then you're unlikely to have further issues down the line. So one question is to not think of it as an or proposition, mediation or courts, but rather, what if you melded them in some way, mediation and legal culture? And could you maximize results in some way by doing that? And I think that there are opportunities for that, and that's the court systems have made efforts to do that in a couple of different contexts that I can think of. And I wanted to describe these a little bit and see what everybody thought about this. So one example in the United States in the criminal context is what we call collaborative courts. So collaborative justice courts are known as problem-solving courts. They combine judicial supervision and judicial decision-making with rehabilitation services that are monitored and really focused on not having someone repeat offender, and also improve offender outcomes so that they're not coming back into the system. And generally, these relate to low-level areas. We're not talking about violent offenders. We're talking about really a complex system of problems that have led to the criminal offenses. So DUI, driving under the influence, mental health courts, homeless courts, sometimes veterans courts, because those who come home from conflict have PTSD and a whole bunch of other problems, sometimes also drug problems that may lead to criminal behavior. And all of these are designed to have the person become more fully functioning in society and to rehabilitate and get them being functioning members of society and contributing, and not putting a further strain on the legal system by coming back to it as well. And the way this is accomplished is very different from other criminal cases. Now, I have served on these courts, and it's very interesting because it really is itself what I think of as a collaborative mediation culture process. And those who come to it, those lawyers who come to it in an adversarial way, do not do their clients the best justice, and they don't lead to the best outcomes. You have to really reframe their perspective about what they're doing. So before a number of methods, the probation department will look at it, the mental health department will evaluate them. A lot of people will evaluate them, including the judge, to assess whether they're possibly a good candidate to go through this program. And then the program usually is about 2 years of staying sober, checking in, coming to court. You know, they have to get a job. There's various things that have to happen throughout this process before they can graduate the program and move on to be a much more productive member of society, and really to get their families back too. You can see their families are very happy to have them fully participating with them. And so that means literally all of those people sit around a table in the beginning to make the assessment. And then every time they come to court, which is once a week or every other week, the same people, all of them, probation department, mental health, the court, prosecutor and defense lawyer, will all sit together and say, what is the best thing for this person? If they have slipped, you know, what do we do to help in that recovery? What kind of, kind of restoration thing do they need to do? Do they need to go to jail for a couple of days? Do they need to do something else? And everybody's decision is made together for the benefit, the goal of the person getting out of the system and becoming productive. So it's all meant to help that person become more whole. And for those who come to the system with an adversarial way and thinking, whatever the prosecutor says, if I'm the defense lawyer, I disagree with that and I'm not going to listen to it. Like, no, in this case, the prosecutor's really trying to work together with everyone to say, what's the best for this person? So even though there's certainly a larger context of the rule of law and, not having, and also legal resources, that's really all everyone in the system is working together to enhance things for this person, even if it might mean tough love at a certain point in time. And there, all of these same type of approaches are used in all of these different courts. And then also the peers also kind of help each other. So the courts are organized so that there's always a group coming into the program and a group graduating at every court hearing, both to give hope to the participants that they can graduate in the future and get to that point, even if they've slipped, to show the people who are literally in handcuffs in the holding cell in the court who are being considered, like what's possible in this program. And also to make the judge feel that even if people are having a hard time, there's a light at the end of the tunnel and there's a reason for doing this. And that's many people make it through in a very positive way, and that you want to encourage that. So it's meant to kind of uplift everyone, the whole structure of it, even if there are some tough love moments there. And so it strikes me that this system really is not a purely what we would think of as a purely legal punishment system. It's really meant for reform, and it's directed at, in a mediation way, collaboration and efforts to maximize the results for this particular person and their family and their community. And there's a coordinated strategy between everyone that is important as well. So, and then the people who are involved have to work really hard to meet a lot of really high standards. But it seems to me that that is one example where the legal system has incorporated aspects of mediation and mediation culture into legal decision making and created something vastly different from a typical criminal legal proceeding, and yet have created some really good outcomes, both for the system but also for the individuals. So that's one example that I have. And then I wanted to talk about on the international level, as I mentioned, kind of talked about, cross-cultural, that every mediation is cross-cultural. And I think in the international context, that's literally true. And it's also in the context of human rights courts, even a bigger issue, because you have the human rights courts will not become involved unless at the national level, the legal system has utterly failed. So you're asking someone from outside to tell someone to clean up their act, basically, and to have their legal system function in a way that comports with human rights norms and requirements. And it's a system that's already failed. So you need to have a different approach with regard to making change happen, because it isn't a top-down system within the country's own legal system saying, we're the Supreme Court and everybody follow us. No, you're translating it from the outside and saying, as a diplomatic matter, this is something that your country has agreed to. Your country has agreed to abide by these human rights treaties, and you have not in your legal system in this setting. And so there's a little bit of diplomacy involved in those decisions in order to make them actually have change. But then also they have a certain amount of freedom in the remedies they can provide. It's really much more of a restorative justice approach. And to that degree, it made me think of mediation as well, because the range of remedies that you can get in these proceedings are really vast, and they're not the kinds of things that typically courts would order, within their own country, for example. So I wanted to give an example. One of the cases that I worked on that was in the Inter-American Court of Human Rights. And the decision came down in 2010. And the Inter-American Court is located in Costa Rica, but they hear cases against all of the Organization of American States. So we're talking about North America and South America and the treaties that bind those countries. And so Mexico had become a member of the Organization of American States, and they had also agreed to a human rights treaty and a women's rights treaty. And so this case was the first case to discuss the interpretation of the women's rights treaty and what that might mean as compared to human rights. And this case involved the decades of disappearances and murders of women and girls on the border at Ciudad Juarez, which coincided with NAFTA and really the creation of overnight of a number of factories that showed up on the border in Ciudad Juarez, which led a lot of young people to come from all over the country to move there and to take jobs. And so there's a very vulnerable population as a result of that, away from their families, many of them, and at risk in a city that had not built its infrastructure up enough to take into account all of these factories and things like that. So no roads, no lights. It was an issue when people went to the factory to work early in the morning. And so women and girls were just disappearing and showing up decapitated, all kinds of really horrible things around the city. And no one was being investigated and no one was being prosecuted. And so over many years, it just piled up more and more because there, as the Inter-American Court said, even though Mexico may not have been complicit in or committing these murders as a government at that point. After so many years of doing nothing, they had essentially allowed it to continue and allowed it to escalate, because if people know they can do those kinds of crimes with, no repercussions, then it's going to encourage more of those crimes. So that's what the Human Rights Court decided. It said, yes, Mexico is required to protect and ensure the rights of its people, including women and girls, and that includes being safe from violence. And we see that the Inter-American Court thinks that these problems are really systemic. They come from views of women in society and a whole bunch of perspectives, but also therefore priorities or lack thereof in the police department and things like that. So in crafting what the court thought was the appropriate remedy for this, the court had a number of remedies which you just would not see normally in a traditional court decision. One was to put a memorial in the field where these particular girls, so there were a few mothers who had filed these claims for their girls that they had lost. Some of them were 14 and 15 years old. One of them was on her way to school when she disappeared. So a memorial in the field where the girls' bodies had been found in honor of them. Now that was important because Mexico was disputing for years that these disappearances and killings were even happening. So first is to acknowledge that something can happen and to memorialize it. A public recognition by Mexico of its own fault, both in a ceremony and to print it, to publish it and tell the world and the country that they had some responsibility. A website listing of all of the women who had disappeared since 1993, so for 20 years. A payment of money to these particular families, and then a requirement that Mexico properly and fully investigate the murders and disappearances, including funding this. So having a special department that's focused on crimes against women and to actually go and do this. And then the court monitored these and other remedies every year. So it's just like a civil rights settlement in the US. People, the court comes in and says, are you doing what you're supposed to be doing? And if necessary, the court will tweak it a little bit or suggest other things. So to me, this shows both this, a non-traditional approach to the legal solutions to the problem, also trying to deal with a problem that the court recognized itself to be cultural within Mexico. So a view of women that is the underlying cause of sort of percolating under all of these failures at so many levels: police, national and elected government, and at the judicial level, and even at the local community level. So it's that effort to get to that, and therefore these solutions are efforts to work on that cultural issue, again, which is a little more difficult because even though Mexico had agreed to this treaty, it's still being somewhat imposed by the outside, right? Mexico didn't fulfill it, and now an external entity is telling them they need to. And this is common in the international realm with the Inter-American Court in particular in terms of its approaches to remedies, because it's working often at a cultural level or a failure of the national level of a judicial or a rule of law system. So sometimes I'll give some examples of some of the things that we had actually asked for in the case too. I mentioned the infrastructure was a problem. One of the things we'd also asked the court to do, which the court did not go that far in doing, was, hey, could you require them to build some roads, put some lights up, have some transportation for people who are going to the factories in the early morning, who are generally young women? That would really be a deterrent crime, even if you had lighting and other things like that. Now they didn't do that, but it is something that has been ordered in other cases, which to me again has it's a much broader view, and I think of a mediator view of a problem, because you're looking at the underlying contributors to the issue that has come to court. So so that has been ordered in some cases. Sometimes the memorials, commemorations, the publishing. I also wanted to mention the publishing. So the court also ordered publication of the key parts of its decision, which it laid out what they were, and said, okay, these will be published, and we're ordering them to be published by the newspapers. And the reason they did that was because obviously they want to get the information out and have the government not deny that this had happened, but also because journalists who printed things that the government did not want did not fare well. So they wanted to be clear that they were ordering this, and the reason the papers were printing this was because of the court's order, not because of an independent decision by the newspapers. So that not only does it get out, but they're kind of insulating the newspapers from any blowback against them. And that to me just, when I realized that, I was like, wow, this is different than what I'm used to for sure, but it's an important thing. And other things that have been ordered in other cases by the court, I'll say in a redress order for a Mayan indigenous community for a mass murder that had occurred many years prior, the court ordered establishment of a village housing program, implementation of educational and cultural programs, same kind of public acceptance of responsibility, investigation and prosecution, translation of the judgment into the indigenous language so that everybody could read it directly, free medical and psychological treatment for some of the people who had been victims of rape. So it's really this holistic view of what they're trying to get to, and trying to heal things, I would say, at much more of a restorative justice level than many courts look to. And that itself is a recognition that they're working cross-culturally and they're working at a much deeper level in these cases. And also that there's a significant benefit to addressing that. And those kinds of attention to things that mediators pay attention to is something that gives the international courts, that's something special that they have, because they're looking at the whole of society when they're looking to create remedies. But at the same time, the remedies they're creating are not just, they don't have the role of creating a law for that country per se. They just say these are the outer limits, right, under the human rights treaties. And so the way they can have that affect things internally is to think about the issues in a cultural way and to create cultural remedies that hopefully will plant the seeds for change to happen over time internally within the country. And also externally. So these decisions that are by regional human rights courts are also interpreted and viewed by other regional human rights courts. So when the Inter-American decision came out, the European Human Rights Court had a case where they then cited to and looked at this decision as sort of inspiration for how they would apply their law in a gender-based situation. So it has reverberating effects in other regions and also within the countries themselves. So one of the early cases that the Inter-American Court decided had to do with domestic violence in Brazil. And at that time, there was no recognition of that as really being a serious problem or something that should be prosecuted and pursued. And as a result of the notoriety of the case in the Inter-American Court, then Brazil actually enacted a law that addressed this. So it can take time, but it's, it has an effect across the country that they're addressing with their solutions. and they also want to empower the countries to do that. So you want to empower them to be able to come up with their own ways, in addition to the ways that the court has given them in terms of impacting their culture. And I will say also the Mexico decision has had a direct effect on the US as well. There was another case that I was involved in the Inter-American Commission in DC, which issued an advisory opinion for the United States in light of the case against Mexico with regard to the US's implementation of its domestic violence laws, even though it has very strong local domestic violence laws in many places, and even requirements that if there is an order that's violated, that there be a mandatory arrest. That didn't happen in a particular case. And so the police did not implement from the judicial and legislative realm. They didn't implement what those had required. And so the Inter-American Commission said, no, you have to respect and ensure. And that means at every level. It isn't just writing down a law and then letting it sit there and not implement it, and not implement either the domestic violence order or the mandatory arrest law that the legislature had enacted. And so that decision really layered on top of the Mexico decision and has influenced a lot of local governments in the US in terms of how they implement those orders. So there's a lot of reverberating effects as well, and a lot of impact in that particular culture, but then I would say on the international level as well, because it has a certain profile that makes people think about these issues and how they can maybe do better culturally in their country. But to me, that thinking about what Ken was talking about in terms of cross-culturally, and also in terms of the depth to which mediation can resolve problems, circling back to his point of where conflict can arise, it seems to me that both the collaborative courts in the United States system and also the international human rights courts really incorporate some of those principles and try to get more holistically to the issue, either to prevent as a preventative measure for future events, and also restoration with regard to what has happened in the past. And that to me is a special view that a mediator usually holds, and that is being shown here. So I think there's potential for, if the legal system continues to, as they say, think outside of the box and look to resolving some conflicts with more of a mediator's view, then there might be some interesting results from that. And certainly we've seen just at the collaborative courts level in the US that has made a difference. It certainly makes a difference if you change one person's life in that way, that they are not going to, they're going to remain sober. They're not going to engage in some of the unproductive behaviors that they have in the past. You can see the immediate reverberation of that to their loved ones, to their work, to their immediate community, and then that kind of rippling out throughout the community. And so there's a lot of positive things there, and that comes from the collaborative and mediation approach, and really not from anything else. So I think that when we're thinking about mediation or the law, it's not always or. There's definitely an and to consider that not only mediation itself, but also to consider those principles and look at problems at a real depth level instead of putting a Band-Aid over it, and see if we can make people whole and make sure that we're not just repeating these problems down the line. So that's my contribution to the symposium, Vikram. I'd love to get people's perspectives, or your perspective, Vikram, on that, whether that resonates with you, or there are things in India that you think are parallel or similar to that.
What we have in our constitution, we have the Supreme Court and our high courts. So we have articles specifically there that they have a very wide range of directions that they can give. So under that, this whole concept of public interest litigations, the concept came up. So in those public interest litigations, you have all kinds of interesting directions given. So they look at a lot of factors, and say in the case of Supreme Court, whatever the Supreme Court, their orders or the judgments are law. So that is the law. So that way, a lot of things have come out from the Supreme Court like this. So, and those things stand up till a law doesn't come up to change things. So that law stands. So that those are interesting things which have come up, and courts can be creative if they are given that kind of leeway. So that's an important thing that needs to be done. But only thing is, otherwise, other than that particular, those articles that they have, the wide powers, other than that, obviously, then they will have to go into the law and go do that. But there are creative options available to them under those articles.
Okay, that's good. That's interesting, because some cases are better served by that. And right. I mean, I think that's the benefit of mediation, to the extent that people can agree to certain resolutions of things that may not be provided for in the law itself, or be possible directly through the law, but it's the thing that these people want and would really address the main issues that they see. So there's definitely some expansion benefits that you can get from mediation that you just couldn't get from a court of law.
Well, I'll give you an example. I mean, like our city, Delhi, is one of the most polluted cities in the world. So now, basically, people went to the Supreme Court that this is you have to do something about it. Now you have, say, a diesel vehicle. Those diesel cars are registered for 15 years. They're registered with the whatever authority. So the law says that you can be registered, and now you can operate this, run this car anywhere in the country, actually. But obviously, you can use it in Delhi also. But because of the pollution level and the diesel vehicles being very polluted, the Supreme Court says after 10 years, you cannot run these cars in Delhi. So the point is, you created that because you needed a creative solution, and the fact that the law wasn't coming up on that. So that's what I'm just giving you one example there. So where fundamental rights are in any way violated. So there are the interesting things that come up.
Yeah, that's true. So,
but otherwise, I mean, in terms of the fact of mediation, the culture of mediation, I mean, tell us a little bit about that. What is happening on that? Because you're a mature market in terms of mediation. How does it trickle down at the?
Yeah, I mean, I think, well, I think there are a couple of things that are happening that I've seen in the U.S. And I really see it largely from the appellate realm, but still, there's not in mediation, but in the rubric of arbitration, there's been a change where people originally thought that they would just go to arbitration. It would be private. It would be less expensive than going to court, and they could get things handled more quickly and privately. But there's been a change in how people view that, and that more people now also want to build in an appellate process to that arbitration. In other words, they're not happy with the result. They want to be able to challenge it within the arbitration process. Now that adds more expense and time to something that everybody thought, no, we're just going to get this done quickly and privately. But there's been a move to do that. So I feel like in that context, it's adding more adversarial to the arbitration process and privatizing disputes in a way that, may not be good for the judicial system overall. And certainly you wouldn't be getting appellate decisions, but you wouldn't anyway for things that are in arbitration other than very narrow areas. So I've seen that, like an expansion of, I would say, a parallel private judging and court system, especially with COVID, with things getting delayed. There's courts that also, court provisions that allow you to have a case in court, but have a judge appointed that's out of the court. So in other words, essentially a private judge through the public system, and then that person comes back with their resolutions and has the power of whatever the public judge would have. So normally it's retired judges who do this. A lot of people who can afford to do this have been doing this during COVID as well, because the courts have had a backlog, and if you want something resolved, you basically farm it out. The judge farms it out to a private judge. So there's positive and negative things with that. You're having a parallel private judging system for people who can afford it, as opposed to the public system for everybody else. I think also for those who can't afford that, then people are trying to resolve their disputes if they can't get them resolved in court in a timely manner. And so from there, I think you're getting a little bit more mediation in that regard, directly mediating disputes. The question of whether people would mediate before they actually get in an adversarial context, it would be nice if people thought about doing that. I know that it happens in the US in the family law context, that rather than being adversarial through the court process, people try to resolve their divorce outside that in a collaborative way with facilitators. And that's a whole separate way of proceeding in the US. But a lot of people want to be adversarial and don't go to that first. So I see that, but I think with COVID, there's been necessities of figuring out how to move ahead and have the court system continue to be relevant and work with the cases that it has. And so I think there has been some level of creativity there, whether it's saying, okay, if we can't do it, we're going to have a private judge do this. Or also, I think the judges themselves working with the parties to see if there's something they can resolve. So I do think that it's caused people to be a little bit more creative, including the judges, and thinking about how they resolve disputes and whether a trial is necessary. But I don't know that in that context where it's really needs to be, they have a real problem they need to solve in real time, that it necessarily leads to the kind of creativity I was talking about in terms of the international human rights courts, in terms of how broad the resolution can be in a particular case. I think that isn't necessarily being explored in that degree. But I do think that to solve longer term problems like the collaborative courts have tried different, and that's come from judges, different judges who had ideas and saw things in their court and said, hey, if we tried it this way, maybe it would be helpful. And now in California, there's over 400 collaborative courts. It started with just a few judges who saw these issues and saw a better way to handle them. So I have hope that with new challenges and with COVID, that a few judges who innovate and see things more holistically will come up with new solutions that will become institutionalized, like these collaborative courts have been. Really, I'll say in that context, the collaborative courts became popular. It was important that people became productive members, and the individual impacts were important to the individual judges. But I'll say the funding for those courts became possible when those judges were able to show exactly how much money they were saving the state in not sending these people back to jail many times. So when you're saving millions of dollars for the state, because you're not jailing a whole bunch of people who now are not recidivists, then it becomes a clear value proposition for the state to fund these courts and to make sure that people are productive, even though the impetus for it may have come from judges who had a mediator's view and a holistic view of the cases in front of them and the very individual humans who they saw in their court every day. Really at a systemic level, it became possible when people realized, hey, this is really good for our budgets. We cost X amount to fund these courts, but look how much it would cost us overall, the state overall, in terms of prison and jail. So I'm hopeful. I'm hopeful, Vikram, that there will be more innovations, I'll say.
But MC, you have to tell us about the lawyers. How are lawyers adapting to media, or have adapted to mediation as part of the entire culture? Because that is one thing that you hear all over the world, that there is a resistance from lawyers. So how does that work in the US over these years?
Yeah, I mean, I think you're talking about someone serving in a very different role, right? So So those who are hired to be the warriors, in the adversarial system, the litigators, the trial lawyers, and even the appellate lawyers, we're raised in a system of adversarialness, and we're just there to fight, through the system. And I think that it's hard to get out of that role when that's how you've been trained, and that's the role the system puts you in, except for a few places, as I said, the collaborative courts and things like that, where it comes down from the court system itself. And even in the appellate realm, there's certainly court-ordered mediations. There's some very robust mediation programs at some of the federal circuit courts of appeal, where there are very experienced mediators who are hired and on staff for the court, who facilitate efforts with cases to resolve them, but also to manage them in a way, both in terms of timing and organizing them in a way that helps the judges with their caseload, but also they look at resolutions, I will say, in an interesting way as well. They look at it in terms of a really good candidate for mediation for the Ninth Circuit mediators, for example, is one in which there's an appeal, but there may be other cases elsewhere in the system. So other related cases in the trial court or other related appeals that are coming up. And they look at all of those and say, okay, there's a bunch of fights between these parties. How can we resolve all of these now? Even though only one of them is in our court system, there may be other things that we can do to resolve the whole thing together and to look at what is the root of the conflict for all of these people. And I think just by having the mediators have that perspective about what they think is a good case for mediation has caused some people, at least I always do, when I look at the cases now, I go, okay, is this a good candidate or not? And when I look at it, I use the same framework saying, look, I know they may be able to resolve all of these things for my client. And that would be, maybe in this case, a good thing. They wouldn't have to fight on all of these fronts, and we could get some kind of resolution to all of it. So I'm hoping that the approaches that the court, very good court-trained mediators are bringing to the cases will trickle down to the attorneys who are handling the cases. I just think it's very difficult when you are in the role, you're hired to be the adversary and the fighter, and it's hard to pull back from that and look at it overall. What are you trying to get out of this? I know you're in this fight, but what is your purpose? And can we work with that in another way? So I think it's hard to just shift, even as someone who has a mediator's mindset in many circumstances. It's hard to do that, Vikram.
So I was just going to get to this mediator mindset, because I had you on that show in Conversation with the Beautiful Mind, because I know that you have the mediator mindset. So you cannot say that we appellate lawyers and the adversarial mindset. You cannot say that. It will go against the whole concept of my show. So we'll just
I'm just saying in general, it can be,
yes.
it means a shift, and it's a shift in a way of looking at a problem. And that's why I think that Ken's presentation was so good, and he really crystallized it. Lawyers and judges are just looking at the problem that's presented to them, and the framework is presented to them, and they're given a framework to resolve it. But there are a lot of other things that are involved in that. It's really an artificial construction of the problem. There could be a whole lot of other things that are contributing to that, or like, what is the real thing? Like, what's your real beef? What's really going on? What's the relational conflict? Things like that. It comes up obviously most often in family law and things like that, where you have ongoing relationships and ongoing conflicts, and there's a whole history to the case that's showing up in court. And it makes it difficult for the family law judges to resolve things because sometimes people don't want to resolve them. But yes, I think the judges who put the collaborative courts together have a mediator's mindset in terms of how they approach things. So I think just having different diversity in thought in approaches to problems. But I agree, Vikram, it can be that the lawyers can be a barrier to mediation. But I think that once they see the value of it in a particular case, I think they're able to kind of issue spot and find another case where it would hold that value. And for those who are problem solvers for their clients, not just warriors, they'll see that. They'll say, hey, one size fits all is not the best approach. This seems like a better approach for this particular case. And if you spend time, as many clients say they want you to do, not just looking at their particular dispute, but understanding their business or understanding more holistically about them, then you can find resolutions that may not be adversarial. It's unfortunate, though, by the time you get to adversary, it's hard to get the other side non-adversary too. So you got to work on that.
But at the end of the day, basically what you're saying is at one end, the role of judges to a certain extent has to change, and however the framework has to be developed around it, that's one. And of course, the role of lawyers in general, obviously, we keep discussing that, the role of lawyers. First of all, was it supposed to be what it's become, or was it something else and it's become this? We moved in a certain direction for whatever reason. So I think that aspect also needs to be discussed. And maybe like when I say we have to go back to our roots in terms of mediation, maybe if, as the legal profession, we have to go back to what it was supposed to be. So we have to understand what it was supposed to be. I think we'll have to have a discussion on that also.
Right. Yeah, exactly. I also think that when you're talking about cultural, like that we have mediation in different cultures, those are really very, when you think about that prototypically, they're really local or tribal or something where the whole community takes responsibility and you take responsibility to the community. I think that there would be benefit to that, right? To reinstilling or to reminding people of those kinds of values in taking approaches to problems. There'd be a whole lot less strife overall, and hopefully happier folks. And I think that the system, by growing beyond that, the legal system has become its own entity and has pulled back from that practicality in a way about how to resolve things.
I think that's why I think maybe on these things that's why you have to go back a little bit to see where things changed and what was the circle, because there is a society which is developing, so a lot of factors are part of that development. So you can't pinpoint one thing and say, okay, let's look at this, and because of this happened. It's a very so many things are happening at the same time. So I think maybe you have to go back, and maybe because society definitely gets restructured on a day. This pandemic has restructured things for us. So what changes might have happened today after 50 years when we look back? If people would, only if you look back, you would know what happened. Otherwise, you would just forget about it. What happened in 2020? Who knows what happened in 2020? In 2060, you won't be talking about that. So, but things have changed. We've gone into a different direction, and that how that develops and how that moves on, we don't know in the next 5 years where we're going to go on that. But things have changed, definitely changed. So, what happens at what point, we don't really know. But I think that the important thing is that at the appellate level, there is, that mediation at the appellate level is not something that I've seen being discussed here at that much, because we have so much work at the other at the basic level.
Yes, but and I'll say there were a lot of people who are very skeptical about that being useful at that stage, because the thought was that most people are deeply entrenched in their positions by then. They've been fighting in the trial court, and how could you ever get people to come together to talk and to try to resolve something? And it's turned out not to be a barrier. It is in some cases, but in other cases it hasn't been, because once you're on appeal, it's a whole new beast in the US in terms of how you argue it and what the standards are. And you have kind of a fixed thing to review, where everybody has come out in the dispute so far. There's uncertainty about what might happen at the appellate level, and the appellate level has a whole new really way of a different approach to the arguments and a legal focus that allows kind of a fresh look at it, because however the trial lawyers evaluated something for trial, the factors and elements now on appeal that you're going to look to as to what the appellate court is going to do is very different. And so there is an opening during that process to sometimes to mediate and resolve things.
I just did that. I just did that.
Yeah.
This is a appeal lying in court, And for years, this matters because you know how long it takes. I don't know how long it takes there, but here it's like this was about, I mean,
longer,
almost
I think.
much more. I mean, here it was, no, no. We were talking about a matter which is still lying in a certain court for about 12 years. And then it has
Oh
to
my
move
goodness.
from
No,
there
not
to
that
the
long
Supreme
here. Yeah.
Court, which you don't know, maybe it could take another 10 years. It's that bad. So, but that got resolved.
Oh,
It was, I mean, so this is at the appellate level, is at every level, I think it's important because people are stuck
yeah.
in a certain process. I'm trying to
Yes.
look, you won't even be able to understand this from the Indian perspective. 20, 25 years, a matter in courts is huge. So I don't know. I
Yes.
mean, for you
Yes.
to be able to understand that also will be like, how does that happen?
Yeah, that's much longer than ours. I mean, people's clients will say, you know, oh, 2 years for an appeal, that seems like a long time, but you know, not compared to your situation. I'll say, well, now I have a good comparison in terms of how much longer it could be somewhere else.
Yeah, it's crazy.
But
Yeah.
yes, the delays certainly, right? If you, that's another aspect. How long is this going to take? And the answer in your case is nobody knows, but it could be really long. That's an incentive to have people come together and figure out if they can reach some kind of resolution.
But I think, but one discussion we've been having, and I've had quite, I mean, a number of such meetings and everything we've had, is that why do people want to go into court? So why do people want to arbitrate? So that is one thing. You, what from your side, what do you think? Why do they do that? Is there something that you've been able to figure out from their mindset?
Yeah, I mean, I think part of it is that the when you get to that point, the getting back to Ken's points, like the relationship has devolved to such a point that it would be near impossible to have these people consider sitting down with each other with a third party to agree on anything. They've kind of, whatever relationship has just totally disintegrated, and there's no trust. And you know, trust is important to doing that. And even if they might trust the third party, they wouldn't trust the other person at all. And then I think the other part of it is that some people just want to be right. They want to go, I want somebody to say I'm right, you know, about this, and that I win. There's a winner and a loser. And I want somebody to come out on my side, and I'll feel better, you know, when that happens. But I think that people don't always calculate that once you start that, the legal process itself is its own, it becomes its own entity sort of outside you, and has this own process through the system that you really can't control after a certain point. So once you've initiated it, you know, it could go on for 12 years or whatever it is. You might want
20.
your vindication now, or 20 years. Yeah. But you're not going to get it, as it turns out, because the system is going a certain direction and is not fast. So that's why I think even those who come with a sense of retribution or vengeance or vindication or something realize that they're not going to get a quick fix, and maybe even they might at some point decide that a mediation might be a better way to get some kind of resolution, rather than to be in that limbo for so long. So I think that, yeah, I think those are like the main things that I've seen with people. And also, I guess the third one would be leverage. If you file a lawsuit, you have leverage to negotiate a resolution that you wouldn't have otherwise. You just have a threat of doing that, but once you've done it, then you have some leverage. And that goes with the same people who kind of, you know, maybe a business calculation of leverage, but it also might be the people who have some level of revenge or something in their heart that they want to achieve through the case. So, so I think for that, I just don't see how you would send people. People have to be willing, right? There's an agreement and an agreement to the procedures, agreement to the process, agreement to a resolution. They have to be in a spot where they want to do that in order to go to mediation. And sometimes it takes people going through the adversarial system to a certain point where they go, this is not what I thought it would be. And it may not even get me what I really want. Then they start looking outside that. And I think if you can also catch disputes before they get to the adversarial setting, you might also be able to mediate them. And I think that gets back to the roots of this in terms of, you know, a wise village elder or something like that, where you say, oh, we're going to take our our dispute to someone we both trust already, and that we will abide by that decision. And I think that kind of paradigm is what people have in mind, or you have to have in mind for mediation in a way.
But that part of it, what you just said, I will definitely get to that. But before that, this aspect of why do people litigate or go for arbitration? Because there were inputs being taken from people all over the world. So interesting thing that came up was that people don't want to take their decisions themselves. They want someone to take their decision for them. So it's maybe is it a cultural thing?
Oh yeah, it would be. Well, it takes. That's what I'm saying too. Is it takes a certain level of responsibility, right? You have to take personal responsibility for the dispute and for the resolution that you agree to. And it's a good point, Vikram. Some people are like, no, I want somebody else to resolve this and therefore declare me a winner, or somehow I don't have any responsibility for it because this person's going to do it. Yeah, you're right. So that goes back to Ken's point of the individual, right? The internal conflict. That's something that people need to kind of work on before they can, have a successful mediation, I think.
But the other interesting thing that you spoke about, the village elder concept, this is what we have been discussing on various sessions, because there is one understanding that is being, which obviously was something that I thought would come out, is that the fact that the mediation concept was there in the culture of places all over the world, they would be there. But sometimes it comes out that actually, like you said, the village elder is actually deciding for you. So you abide by that decision, like you said. So I think that part of it is something, if that's in the culture, then that means mediation is not in the culture. Then to say that we have to go back to something might not be correct. So we were just discussing that in the last with the person from Africa, from Nigeria. This is exactly what we were talking about, because it all turned out that all those situations, they were being told what to do.
Yeah, so it's essentially just a court system in a way.
Something like that, yeah. So you
with a trusted person.
Exactly. So you have this person who has that. Let's not say, of course, trust is not an option you get. It's respected in society. So you just have to go there.
Right.
So trust or you don't trust, you don't have an option. So so that, I think that part of it is what actually needs to also be clarified, because whenever you go out and say it's part of our culture, and then to say it's something that you are familiar with, and you use a certain word in that local language or in that local culture, and it turns out that was someone making a decision for you, so then the whole concept of party self-determination and all those aspects just go out of the window. So that was, I'm trying to be very careful with this aspect. We're trying to bring it out.
That's a really good point. Right? It depends on how that's done. Is it really facilitated in a mediation approach, or is it really just like, hey, we trust this man or woman and we're going to abide by whatever he or she tells us is the best result?
So basically, we had a very long discussion just before you came in. Actually, this was the only thing being discussed, because the person who was presenting it for the person from Nigeria, her mother was also there. So I was asking her mother. She's here. She's here now. She's here also. So I was asking her that, what do you remember in terms of society as you grew up? But I mean, there are cases where finally I was taking them through that definition in the Singapore Convention, which talks about the person should not have an authority to impose a decision. So that is what, then once she read that, then of course she was looking at it in a different way. But out of that, one interesting thing that came up was that they have this whole concept of, you go to a certain person, whatever that, I mean, ritual or spiritual or whatever way, the person actually tells you who is the offender, and everyone accepts it, that okay, this is the offender. So you have systems like that. So lots of interesting things you bring out from all over the world.
Oh my goodness, that's so interesting. Yeah, and I think about the way the mediators operate, we'll say in the appellate courts, for example, it's very clear that it's the parties who have to agree. He or she will always say, I can't do anything unless both of you agree to this. So you have to, come to me together with some kind of proposed approach, and then I'll help facilitate an approach, listening to both of you separately or together, and maybe come up with a new idea. But it's very clear that mediator is not an arbitrator. They don't make decisions, and they say, we will help facilitate whatever it is that you want to accomplish. You can propose things that you agree to, and maybe we can say, oh, there's something else I can do within the court to facilitate that. How about this approach? But every time we do anything with the Ninth Circuit mediators, for example, they're always saying, are you both on the same page? You know, are you both coming to me that this is what you want to do? If you aren't doing that, I can't do anything for you unless you want me to talk to the other person and see if we can find a way to agree.
Well, that aspect also we were discussing before this whole purist approach of the facilitative aspect and not being evaluative at all. That is one approach. But again, I always go to that. There's that definition in Singapore Convention, which says whatever way the process is done is immaterial. It is still mediation. So because so this aspect has to be really clarified, because it's such a wide term to say this is not mediation because you went evaluative will be the
No, I think that's right. I think that's just a, you know, and I think there's different ways to be evaluative without being, you know, a decider about things. I mean, I just say that I was just mentioning that in terms of the mediators at the court, because people are in an adversarial proceeding, but then in this pocket of mediation, and to be clear at all times that this is not adversarial and I'm not going to direct anything. But that's not to say that they're not individually speaking with participants and, you know, facilitating a dialogue in a way that could be deemed evaluative at certain points. It all depends on, you know, how I think adept you are at doing that and moving a mindset along.
Well, we had this discussion on this is actually could be a cultural aspect also, because some cultures want the person to be evaluative. And there was one of the presentations that Gunavathi from Malaysia also made, that they want the person to be evaluative and might not think there is any value in the mediation if the fact the person was not evaluative, did not suggest.
Oh, that's a good point. Why are you here? Right.
Yeah,
you know,
exactly.
this is what I want. I want you to do something. Yeah.
What have you done?
Right.
So it's a cultural
Well,
thing.
I mean, I think in some ways, you know, when, you know, Ken was talking about some of his experiences, I'm like, wow, if you really do a great job of having people have buy-in and create the solutions themselves, you might lead to the point you're talking about, which is you're like, why are you here? You know, what did you do? We did this ourselves. What are you talking about? And to some degree, that's like true success, right? Because they own it. They own the resolution. They own the process. But on the other hand, they've forgotten that how they got there was through the mediator. So it's a fine line there.
Yeah. But now I want to introduce you to Isaac. He's a very enthusiastic person from Ghana. What I like about him was he took this whole thing so seriously. I don't know whether I sent it to you in that email also, that he went out and sent a form outside asking for input from all over. So I was really happy that someone has actually gone out and wanting to get information, because there is so much information out there which obviously not party to. So Isaac, please, you can say hi to MC.
Hello.
Hi,
it's good to have you. Hello.
Yeah, good to see you. And thanks for participating so robustly. I saw that too with the email. I was like, oh, that's great. That's the part I was talking about, Vikram, creating a community and having people, you know, trading back and forth. Yeah.
Sure. It's good to hear from other cultures and other things and what is happening elsewhere, which is really good.
Yeah. Well, and I think it gives good ideas to all of us, right? You hear different perspectives and you're able to discuss them. And then I think sometimes people, you know, even in your own country, you say, well, this is how we do it. And, you know, somebody from somewhere else will go, well, that's not how we do it. There's another way. And it kind of opens your mind up to possibilities, I think.
Exactly.
Sure.
Yeah.
Great.
So anyway, thank you, MC. And I mean, why I'm saying thank you right now is because of the fact that I'm trying to keep them shorter. We can have a conversation after this. No, yeah, why? Because I'm trying to keep these videos shorter, other than the ones that I have, those 2-3 hour ones, because
I know
people don't end up watching them. They watch them in parts, and of course they've been watching them, but in parts. So I wanted to give them something that they would really sit down and watch. If it's an hour, I think
Right.
it might be still possible. So that is why I've been trying to keep them.
No, I was
short.
watching the time, Vikram. Don't you worry. I was watching it. I'm taking your lead. I'm good.
Perfect. So anyway, thank you very much for your inputs and your insights. And I'll stop the
Thank you so
recording
much.
here, and
Okay.
we can continue our conversation.